So in today's webinar, which is a part one of a two-part series of webinars, we're going to be talking about management companies, management agreements, and managing agents. My name is Gemma Bell, and I'm a partner here at Devonshires, specialising in banking, corporate and governance. So unexpectedly, I'll be talking about the kind of corporate and governance elements around management companies and some of the headaches and issues that we've helped clients with through the years. And then I've got Stavrina with me today who's a partner in our real estate and projects team, and she'll be talking more about the property and development aspects of when management companies are useful and when you might want to set them up. So in terms of the topics today, as I said, this is a two-part webinar series. We have a second one coming up on the 13th of October, so if you haven't already, please do sign up. In today's session, we're going to be looking at in what circumstances you may want to set up a management company and when it can be useful. Secondly, what property aspects should you be considering when you are setting up a management company? Thirdly, how do you look at setting one up? Fourthly, how does a management company operate in practice? And then the last point is around what are the governance considerations in setting up a management company? In our second webinar, which is on the 13th of October, as I mentioned, we're looking at things around relationships between management companies and managing agents, how management agreements work in practice, and some best practice tips really around drafting management agreements and managing those relationships. So on that, I'm going to hand over to Stavrina, who's going to talk a bit about what circumstances might mean that you need to set up a management company.
Thank you, Gemma. So as Gemma said, I'll be talking you through the circumstances in which a management company may need to be set up and the different types of setup available. So normally the landlord or the freeholder will be responsible for the overall management of a building or estate. However, it's become increasingly common for landlords to set up a management company to take over the responsibility of managing and maintaining the building or the estate. So if there are communal facilities within an estate and the obligation to collect service charge, then a management company would usually be set up to take over these responsibilities. The management company would also take over other landlord or management company responsibilities within the lease, such as insuring the building. There are a number of different ways in which a management company may be set up and appointed. So the first is by way of a resident management company. So in this circumstance, the landlord may set up a management company prior to completion of the sale of the units. And then on the sale of each unit, the new owner must become a member of that management company. On the sale of the final unit, the landlord transfers the estate common parts to the resident management company, and the landlord can then walk away. The management company is then the responsibility of the residents, who are all now members of that management company. Alternatively, a landlord may want to retain the estate common parts, in which case they'd set up or appoint a privately owned management company. They do this before completion of the sale of all the units. This type of management company would assume the responsibility of the estate common parts, and the residents would not have an interest in this type of management company. The benefit of this is that the landlord retains a long-term interest in the freehold of the estate and could potentially sell that interest in the future. And the final option, which I'll touch on today, is a right to manage company. This is where the leaseholders have a right to form a management company, and Gemma will be providing you with a bit more information on this later on. Next, I will be talking you through property considerations when setting up a management company. So the first one is ownership of freehold. So the first thing to consider is who owns the freehold. Is it the developer who's granted a leasehold interest to the registered provider? If so, then the developer will usually set up the management company for the whole estate. If, on the other hand, the RP is the freeholder, then it will be their responsibility to set up the management company. Also, if the management company is set up by way of a residence management company, then the landlord can only transfer the freehold to the management company if they actually own the freehold. So it's important to just check whether you own the freehold when considering setting up a residence management company where you want to transfer the freehold. The next thing to consider is the lease and the transfer terms. So the transfer from the developer to the RP must contain reference to the management company and set out what the management company's obligations are. There should therefore be a clause in the transfer for the management company covenants. If the management company is set up by way of a resident management company, then the lease or transfer to the individual residents must contain a clause which states that on each assignment of the property, the new owner must become a member of that management company and that they covenant to comply with the covenants and obligations in the lease. This brings me nicely onto shared ownership leases. Shared ownership leases differ slightly, because you have to first consider, do RPs want shared ownership tenants to become members before they staircase to 100%? Most RPs wish to retain control prior to 100% staircasing and therefore do not want shared ownership tenants to become a member of the management company. This means that the RPs will still be on the hook until the tenant staircases to 100%. It is important, therefore, to ensure that the grant of a shared ownership lease is not caught by any restriction contained in the transfer from the developer to the RP, which requires an assignee to become a member of the management company and to enter into a deed of covenant. This can be done by ensuring that the wording of the restriction refers to any transfer and not any disposition. The grant of a shared ownership lease will therefore not be caught by the word transfer. Alternatively, the transfer can define the grant of a shared ownership lease as an exempt disposal, which is not caught by the restriction. It's important to remember, however, that on 100% staircasing, the tenant will need to then become a member of the management company and enter into a deed of covenant. Next point to consider is handing over of the management company. So I mentioned earlier that the benefit of a resident management company, where each of the residents becomes a member of that management company, is that the landlord can transfer the estate common parts to the resident management company and then walk away from the responsibilities. This handover can only take place once the last unit in the estate is sold. Once the last unit has been sold and the residents have all become members, then the landlord can hand over the estate common parts and exit the management company. I'll now pass you back to Gemma, who will explain how to set up a management company.
Thanks, Stavrina, that's great. So in terms of how do you set up a management company, a lot of it will depend on the circumstances. So firstly, I was going to talk about the right to manage. We're not going to cover it in a lot of detail today, but as you'll know, there's a right for leaseholders to take on the management of the freehold of the building in which they reside. It's different to the right to leasehold enfranchisement, so it's not about transferring ownership of that freehold, it's about them having the right to manage that. And they can either manage that themselves or through a management agent arrange a relationship. So if you are looking at a right to manage company, we wouldn't expect that you would directly be involved in that because it would be the leaseholders themselves looking normally to exercise that right to manage, although we have advised some registered providers on exercising that right to manage where they own a number of units or have the leasehold of a number of units within a building. So if you are looking at setting a management company through the right to manage, there is a prescribed format that has to be followed. You'll know there's a process, you have to serve notice in a certain way. You also have to set up a right to manage company which meets the statutory requirements. So that it has to be a company limited by guarantee. I'm going to talk about the different types of corporate vehicle in a moment, but it also has to have articles of association, which are the constitution, which sets out what a company can do, that meet the requirements of the relevant regulations. So in terms of forms of corporate vehicle and legal entity, Stavrina talked earlier about the different arrangements when you can look at having a management company. I mean, you can sometimes look at having a managing agent, which might not be that you look to set up a separate legal vehicle. What we're really focusing on today is setting up something as a separate legal vehicle, which could, for example, own the freehold in respect of communal parts of a building. It can also enter into contracts itself because it will have its own legal personality. So things like contracts for grounds maintenance, contracts such as a management agreement. As a corporate vehicle with its own separate legal personality, it can do all of those things in its own name. In terms of the common forms of corporate vehicle, quite often we'd have a company used for that purpose, and you can either have what's known as a company limited by shares or a company limited by guarantee. Very similar in that there are different levels of ownership and management. You have your directors who are responsible for the day-to-day management of that company and making sure that it's meeting its legal obligations. You can also have shareholders in it for a company limited by shares or members for a company limited by guarantee. Now, shareholders or members are really the people who own the company and who have more limited rights in terms of being involved in that day-to-day management and running. They have rights in terms of things like setting the constitution for the company and in appointing and removing directors potentially, but they don't have general involvement in the day-to-day running. So depending on your arrangements, you may want to look at having either a director or a shareholder relationship with a management company, but I'm going to talk about that in a bit more detail in a moment. So company limited by shares versus company limited by guarantee. Generally speaking, a company limited by guarantee is generally seen as a not-for-profit structure. So we quite often tend to see that being used for resident management companies. So as I mentioned before, with the right to manage, you have to use a company limited by guarantee. Companies limited by shares are quite often used where developers are setting up management companies, mainly because they're a well-known corporate vehicle. And what happens there is, as a shareholder, you're issued with a share in that company. In either form, whether it's a guarantee company or a share company, you have limited liability as a shareholder or a member. So you're basically, if that company were to get into financial difficulty, you're basically only required to contribute up to the level of your unpaid amount on your shares. So for example, if a share is worth £1 and you haven't paid your £1, you'd be required to contribute that £1. Similarly, on a guarantee company, it's whatever amount you guarantee under the Articles of Association. And quite often that, again, will be a nominal amount. So things like £1 again, or in some cases we see a slightly higher amount. One thing just to watch, if you are taking on a responsibility as a shareholder or a member of a management company, what is the level of your liability being guaranteed or signed up to under your share or guarantee arrangements? In some circumstances, we have seen community benefit societies being used, and you'll probably be familiar with that structure because it's one that a large number of housing associations have adopted as their corporate form. Generally speaking, community benefit societies are seen as slightly more complicated for management companies. That's because the law which governs community benefit societies is less well known outside of the direct housing sector. There's a particular piece of legislation which applies to them. They're obviously expected to operate for the benefit of the community, and quite often they'll be charitable as well. So it's not always a natural fit for a management company in terms of the activities being carried out, although we have seen some being set up in that way. As I said, quite often where it's the developer, and particularly if you're working with a commercial developer, they'll want to set up something that's quite straightforward to use and operate, and a company limited by shares tends to be the vehicle that we see used the most. So in terms of how that company operates, it will have its constitution, which is called its Articles of Association, and that will set out really key things such as how directors will be appointed, how voting rights will operate for shareholders and members. I'm going to talk a bit more in a moment about if you're looking at taking on a shareholding relationship within a management company, what you need to be thinking about. But those Articles of Association are something that are quite key. And where we've worked with our registered provider clients taking on quite a significant interest with a management company, we'll quite often work with them on the Articles of Association to make sure they fit with what you need, really. I think it's worth taking things with a bit of a pinch of salt sometimes. Quite often, again, where we're working with commercial developers, they will have a standard form constitution that they'd like you to sign up to. But it's worth thinking about, what's your buying power in this relationship? Does this document fit with what you want? As with all documents, as Stavrina mentioned, those are the documents you can shape to fit the transaction, and that includes the Articles of Association. Although there are certain things which have to be covered off within the articles, there are things you can change to make sure that they are appropriate and really meet your requirements going forward. In terms of incorporation, Stavrina's touched on this a little bit in terms of when you set up the company, the management company, and when it gets handed over to you as well, and that's a point slightly further on down the slide. Thinking about when you set it up within the development process. If you're setting it up early on, how are you going to run that within your group structure, for example? How are you going to manage that until the point that you hand it over if you're the one setting it up? Quite often, if the developer is one setting up, they'll set it up quite early on and then look to hand it over at the point that the freehold is transferred over. Quite a lot of the obligations around becoming involved with a management company will be set out in the lease or the transfer documentation, as Stavrina's talked about. So it's important, if you're getting involved and you're taking on obligations either to become a director or become a shareholder or member of a management company, that you're really clear on what those documents are saying in terms of your obligations. I think the other thing to think about is where you're looking to set up a management company and you're expecting residents to become involved in that. How are you making that clear to them as part of the sales or the lease process, so they understand, what they're taking on, at what point they're being required to sign up to things. I'm going to talk later on about some of the common issues that we see around management companies, and one is really around where we find reluctance or a lack of understanding from residents and shared owners, etc., about becoming involved and what that means for them. So it's really important that you make that clear to them as part of the sales or the lease process, that they understand, you will be expected to become a director of this company, and so we need you to sign up to this form, and going forward you will be required to continue on the board until such point as X. And that's something which I think quite often we find issues with. Similarly, when we see later transfers happening, that can be where we tend to see weaknesses in the process, because although it may be easier to get people signed up early on, when interests are being transferred, it's about how you make sure it's clear to the new purchaser that they're also going to be expected to be involved in a certain way in the management company to make sure it's well run going forward. One thing to think about as well is in relation to HMRC registration. As with all new companies, there is an expectation that you will register that company with HMRC. There are some exceptions to that, depending on the structure of the company, and we can't give tax advice. I'll quickly give my health warning on that. But it's something that we quite often see getting missed. So it's worth checking, depending on the structure of the management company, are we supposed to be registering with HMRC? Has that been done by the developer? Is that something that we're expecting to do ourselves once we get involved in the management company, particularly if you or someone in your organisation is taking on director responsibilities? Because as I'll come on to in a moment, you will then be legally responsible for making sure that that company is meeting its legal requirements, and that includes in respect of tax registration and payment of taxes. So in terms of governance considerations, I've talked already about the different types of legal entity you can have, and it's really important to understand what they mean for you and how they fit with what you're trying to achieve. I'm not going to go through those in a lot more detail. In terms of the management of that company, the day-to-day management sits with directors. So they are collectively responsible as a group for making sure that that organisation, that company is meeting its legal obligations and its requirements as a company. So that includes things like filing requirements with Companies House. That may seem like a kind of very small thing, but we've had a number of issues where management companies have been struck off the register because their filings have not been put into the Companies House on time, but also things like making sure that you're meeting your obligations under your leases or other property transfer documentation. So that can be things like insurance, making sure that service charges are being collected and administered properly, making sure that if you're looking at service charges for leaseholders, that you are consulting appropriately with those leaseholders. So if you are looking at becoming involved in a management company and you're being asked to potentially become a director of a management company, which we know for some of our registered provider clients, they will be asked to do that, particularly where they have a significant interest in that development. It's really important that you understand the responsibilities that are being taken on. And there are duties which apply to directors of companies, which are set out within legislation. So the Companies Act 2006 sets out various obligations on directors that they have to make sure they're complying with when they're carrying out their role as director of a company. And those are things like making sure that you act in the best interest of the company, that you're thinking about how you promote the long-term success of the company, not just in terms of your own involvement in it, but the involvement for all of its residents, for example, and also making sure that you act in its best interest going forward. I'm not planning to go through all the director's duties. One other thing just to think about in terms of the director position is if you are being asked to take on that role, it's really important to consider what the arrangements will be for directors and officers' liability insurance. So that if something were to go wrong, you have that insurance in place to cover the scenario if there were to be liability attached to that. So in terms of liability, there can sometimes be situations in which personal liability can arise for directors, and that includes directors of management companies. Generally speaking, the courts are keen to excuse directors from personal liability where it can be shown that you have acted properly and reasonably and in the way that a normal director would be expected to act. So for example, if you've read the paperwork involved with the meetings for the management company, you've turned up to the meeting, you've been involved in the discussion, and you've made a decision based on appropriate advice if necessary. Generally speaking, if that decision turns out to be a bad decision, the court will still excuse any liability in relation to that because you are acting reasonably and within the realm of reasonable decisions for a director. However, there have been some circumstances where directors can be found to be personally liable. So, for example, there have been some situations linked to things like bribery offences where a director has been personally involved or has known about a situation and not done anything about it. I'm not trying to, be too doom and gloom today and scare people, but I think it's really important that you're clear on what responsibilities you're taking on as a director, what's expected of you in that role. A really key point can be about, what's expected of you in terms of how you represent your housing association when you're carrying out that role, to make sure it's really clear that, I'm here representing X housing association and that's the role that I'm carrying out in relation to this board. And also the insurance point is a really key one, and one to make sure that you do pick up if you are taking on director responsibility. Just a really quick point on directors is that you can also have what's known as corporate directors, which is where a company or another legal organisation becomes a director of another company. So in some circumstances, we have seen housing associations themselves becoming corporate directors of a management company. Generally speaking, that's something we tend to advise against. The reasons for that is it can create what's called shadow directorship liability, where if, for example, the management company were to get into financial difficulties, the creditors of that company could look to the housing association to try and recover that money. There are also some other things which can arise in terms of conflict, so we generally advise against that. If you do have anything where you're looking at similar arrangements to that, please feel free to get in touch and we can give some advice. But generally speaking, we don't tend to advise that that's something to look at in these kind of arrangements. In terms of ownership of the company, as I mentioned, companies are split. So you have the day-to-day management, which sits with the directors who have that collective responsibility for making sure that things are done. Actually, just before I move on to ownership, it's worth just saying as well, although you have that collective responsibility in terms of being a director, you can delegate that to a certain extent. So you can, for example, have a management agreement in place and appoint a management company to deliver certain things on your behalf. So, for example, you have obligations under the lease to carry out repairs. As I'm sure you'll be aware, it doesn't mean that you're meant to be out there with your hammer personally making sure that these repairs are done. You can appoint people to do that on your behalf, but it's worth just noting, even where you do appoint a managing agent for you, and you may only be meeting quite infrequently as a board to come together and make sure that you're meeting your requirements annually, say, that responsibility does still sit with you. So you have responsibility for overseeing that contract and making sure that those duties and those responsibilities are being carried out. Now, it may be, for example, that if you have an issue where you've appointed a managing agent, they're meant to have been delivering a service for you, they haven't done it very well, you know, a resident comes to you and seeks to take action because you haven't fulfilled your obligations under that lease, you may then look to either bring in that managing agent as a co-defendant in a claim, or you could, for example, seek to recover monies from that managing agent. But ultimately, the relationship is between you and that resident, not between that resident and the managing agent. So it's really, again, just remembering that the buck stops with the board to a certain extent, and you have to make sure that you're responsible for overseeing and ensuring compliance in relation to obligations. So moving on to ownership, I mean, it's a slightly odd structure because you may be aware companies were obviously set up to govern a wide variety of different company sizes, from, you know, public limited companies with shareholders where they're placing investment, down to, you know, one-man band companies where it's the same person being the director and the shareholder or member. But there is a distinction in terms of the responsibilities. So as a shareholder or a member, if you're purchasing some units in a building, for example, and there's a management company, it may be that you don't become involved as a director and you just take on a shareholder relationship, become a shareholder in that company, or become a company member in that company. So as I said earlier, you're not involved in the day-to-day running and management of the company. You don't have those same legal responsibilities in terms of making sure that the obligations are being met and making sure that you're there acting in the best interests of that company. But you will still have certain key reserve powers that sit with you as a shareholder or a member. They will generally be set out within the Articles of Association. There are also some powers reserved to you under the Companies Act. So, for example, there is a power for you to remove directors if you were to get into issues with a director who wasn't fulfilling their responsibilities and their duties as you would expect them to do. What's really important in terms of shareholding arrangements and membership arrangements is, firstly, how much of a say are you going to have in this company going forward? It's important for two reasons. One is, if you have a significant interest in a management company, is the shareholding enough? Do you also need to be thinking about having that board role, that directorship role, because of the fact, as I said, you won't be involved in the day-to-day running and management, so you may not be having issues brought to your attention as a shareholder that you would see as a director. The second one is, do you have appropriate voting rights to reflect your property interests? So, for example, if you have 16 units in a 30-unit development, you know, I wouldn't expect you to have one vote in that company with everyone else having one vote as well, because you should have an appropriate percentage of voting rights to reflect your interest in that development, really. The flip side of that, though, and again, I'm going to talk more about common issues, is that what we want to try and avoid is accidentally creating a subsidiary. So a subsidiary relationship can arise where, so say, Joe Blogg's Housing Association becomes involved in a management company, inadvertently, without realising it, takes on 60% of the voting rights at shareholder level. That would then create a subsidiary. So that management company would become legally a subsidiary of the housing association. There are other circumstances in which it can arise. So, for example, you might only have one share in that company, but if you also have the right to appoint or remove a majority of the board, that would also meet the legal subsidiary test. So you might be saying, well, why does it matter? Surely if we've got a big interest in this development, we want to make sure it's being run properly. Why does it matter if we create it as a subsidiary or not? The real issue arises under your funding agreements. So the majority of housing associations will have external borrowing. The majority of those funding agreements will have a restriction in them that says you cannot establish a subsidiary without getting our consent, i.e. the banks have to consent to that. If you don't get that consent, it's an event of default under funding agreements. Now, I will say I have known a dozen housing associations who've accidentally triggered this. I don't know any yet, touch wood, that the funders have then tried to, seek repayment of the loan, but it certainly isn't helpful to the relationship. The funders will quite often become concerned about the fact that, you're accidentally creating subsidiaries here, there and everywhere and don't know that you're doing it. So it's something we try to avoid wherever possible. So being really clear, if you are taking on voting rights in a management company as a shareholder or a member, what does that mean for you? Again, going back to what I said before, making sure that the articles of association are tailored appropriately to what you're trying to protect here, what you're trying to achieve. For example, we have included provisions before that a housing association will get 1 vote per unit, provided that at no point will it ever have a majority of the voting rights within that company, therefore making sure we never trigger that issue in terms of it being a subsidiary. So it's really about making sure that you shape it appropriately. Now, I will say, as a lawyer, of course, I'm saying to you, look at the legal documentation, make sure it's appropriate for you, for the situation. There are some circumstances where there's a cost-benefit analysis here, and it's really, we're buying 1 unit, we're not going to spend X amount of money reviewing and amending these articles and negotiating them. But if you are taking on a significant interest in a development, it's worth thinking about, do we need to do that on this one? Is it right in this circumstance? I've mentioned limited liability before. I think the key thing is you are signing up to a certain amount of liability in any case as a shareholder or member. Generally speaking, it will be nominal. So it will normally be £1 a share or £1 as a member in terms of your guarantee. That's not always the case. So just be careful in terms of reading the documentation and what you're signing up to. It can be increased. So, for example, you may be required to take on what's called a preferential share, which may have a value attached to it. You may be asked to sign up to a guarantee within the articles for a larger amount, though it's generally quite unusual. So how does a management company operate in practice? I've touched on this a little bit already, but generally speaking, particularly for residence management companies, they will operate as a kind of light touch organisation, a light touch board, and they will have a separate agreement in place with a managing agent. And as I said at the outset, we're going to talk more about that in the next part of our webinar series, really looking at some of the pitfalls to avoid there and how that can operate well in practice. But you will have those responsibilities. So the management company will be set up, as Stavrina talked about earlier, to carry out certain duties in relation to, for example, communal parts of the building. There will be responsibilities in terms of insurance, repairs, grounds maintenance, collection of service charges and administration of those charges, upkeeping the structure of the building, potentially also dealing with complaints from leaseholders and making sure that those are dealt with appropriately. Also policing and enforcing the obligations that you're putting on freeholders or leaseholders and making sure they're doing what they're supposed to be doing. Again, going back to that point about directors' duties, if, for example, you were a director of a management company and you had 4 leaseholders in a building who weren't paying their service charges and you did nothing about that, then are you really acting in the best interest of that company? Arguably, no, you're not. So it's about making sure the management company meets those responsibilities under transfers and leases. There are some ongoing responsibilities, so filing, and I don't mean to hammer it home, but we've had a number of issues where filings haven't been done, and that's then led to the company being dissolved. What happens in that situation? Well, arguably, the freehold, which might sit with that management company, then becomes what's called bona vacantia, so it doesn't have an owner and it reverts to the Crown. So we have had situations where we've then had to work for our housing association clients to get those companies either restored to the register so that you have the company still owning that freehold, or you make an application to have that referred, so you have the asset referred to you and you take on the freehold of that asset because that management company no longer exists. But that is something where people go, oh, you're obsessed with filing. It's not just because I'm obsessed with filing, it's because there's a really important circumstance that can happen where you don't make sure filings are done. The other thing again is, as a director, you are responsible for making sure that you meet the legal requirements of the company. It may be you've got a management agreement with another company to do all your company secretarial service and make sure those filings are done. even if you have that arrangement in place, if that's not done, it's an offence by the company, and it's an offence by you as an officer of the company. So it's really important that it does happen, and it's something that you're on top of. I think I've covered off those other points there. So it's really about making sure that even where you have third-party arrangements in place and you have subcontracts in place, the responsibility sits with the board. So you have to make sure you've got that appropriate oversight. You're getting reporting back in relation to the arrangements you have in place to make sure that you can show that you're meeting your requirements, both to leaseholders and freeholders, but also more generally under the law and to your regulators as a company. So the key thing really is about governance considerations, and what's the ongoing relationship you want to have with the management company, and what level of influence and control do you want to have. As I said, the two key levers you have are, number one, your role as a director, and then number two, your role as a shareholder or a company member. And so it's worth thinking about, in terms of directors, if you are going to take on a director role with a management company, who should that be within the organisation? How many people do you want to have sitting on that board? Again, it doesn't necessarily have to just be one, but quite often it will just be one, because, do you need two people from your organisation to sit on the board? A key thing is about how you manage conflicts of interest. As I said earlier, directors have a duty to act in the best interest of the company of which they are a director. So if you, as a representative of your housing association, are asked to become a director of a management company, arguably you owe a duty to act in the best interest of that management company, even if they were to go against those of the housing association. One way to get around that is to have something in the articles which says certain types of conflicts of interest are authorised, so making it clear that you can act in the interests of your representative organisation, so your housing association, above and beyond those of the management company. You can also have those conflicts authorised by the other board members. So there are ways to get around that, but it's particularly key to think about that if you do have a management agreement in place where the housing association itself acts as managing agent. And that's something we quite often see where, as I said, a housing association has quite a significant interest in a development, and it wants to make sure, obviously, those services are being provided correctly, because it's got people living in that building. You want to make sure the grass is being cut and the lights are being changed, and there's not a potential issue in terms of your leaseholders not having a safe building to live in. So quite often housing associations will take on a managing agent role there, but that could give rise to a conflict where you also have someone sitting on the board of that management company. So thinking about how that conflict of interest is authorised, either, again, as I said, under the articles or by the directors themselves, to make sure that if there were, for example, there were to be an issue where there was a concern the service wasn't being provided properly, or there was an issue about the management company not paying the housing association for that service, you would still have the right as the representative of your housing association to be involved in those conversations and to really make sure that you're there to represent X housing association. You can make sure their interests are being put to the board and that you're not excluded from those conversations, and can really make sure the right decision is being made for your residents in that building. As Stavrina mentioned, sometimes tenants or leaseholders will be asked to become directors of management companies. I think it's really key, as I said earlier, that if you're including that and you're setting up the management company, you make that really clear to them that's something that's being expected, particularly for leaseholders, and that you make it clear what their expectations and what their roles are. There's some really helpful guidance that Companies House has put out in relation to what directors of management companies are expected to do. So it's not something where I expect you to be putting on a training session for your leaseholders, but it's about just really steering them and making sure that they're clear on what they're taking on. And I think where we've worked with other clients to do that, what we've tended to find is better success rates in terms of those management companies not having issues where you've potentially got a director on that management company who doesn't understand that just because they're a director doesn't mean that they get preferential treatment, and they can not collect their own service charge and not take any action about that. So those things can be quite helpful, really. In terms of shareholders and company members, as Stavrina mentioned, it may be that you're also looking at shared owners being shareholders or company members. Generally speaking, we tend to see that not happening until shareholders have staircased up to 100%. But there can be different things that want to be achieved there. So we will generally have conversations about what you're trying to achieve and make sure that it reflects how you want the company to operate in practice. So in terms of key documentation in relation to setting up a management company, as I said, the key thing is your articles of association. they're not just something that you can take off the shelf. There are standard forms, absolutely, but they might not be right for what you're trying to achieve. Really is that cost benefit analysis. You know, if you're setting up something where you've got one unit and a 150 unit development, yes, you might want to spend time and money arguing about what the Articles of Association say. However, if you've got something where you've got a more significant interest, it's well worthwhile you thinking about, you know, what are our voting rights under this? What can we do as a shareholder or member? If we're putting someone on the board, what's our appointment rights in relation to that? Have we covered off points around conflicts of interest if we've got an ongoing management relationship, for example? In some cases, you'll also have a shareholders agreement, and that's something that sits behind the Articles of Association, and it's not a public document in the same way the articles are. So the articles get filed at Companies House, anybody can download them and have a look at them. You might in some cases have a shareholders agreement that sits behind them, and that's private between you and the other shareholders of the company. Generally not used in kind of standard development management companies, sometimes in things that are kind of quasi joint ventures but not quite there, and you want to have something which might protect, for example, minority rights. So for example, if you wanted to have a small shareholding in a company but still be able to exercise certain powers, you might do that through a contractual arrangement through the shareholders agreement. Less common for kind of standard management companies though. You'll obviously have your lease or your freehold transfer, and as Stavrina said, that will set out certain things in terms of the responsibilities of the management company, also things about how it will be set up. In some cases, we've seen things included in relation to what would happen if the company was dissolved or struck off, and what would happen with the freehold there. That can be quite helpful. Sorry to talk about filings again, I'm sounding like a broken record today, but if you do have an issue where the company's is to be struck off, that can then deal with that uncertainty about what happens with the freehold, rather than you having to go through quite a costly process to try and get a company put back on the register or to get those assets preferred to you. And then also the management agreement. I'm not going to talk about that in a lot of detail because, as I said, we've got a whole part 2 session talking about what does a good management agreement look like, what are some of the nightmares that we've seen, how can you avoid those. But you may have management agreement in place with a third-party managing agent. So common issues, and this is, to be honest, this is where I tend to get involved. So I may seem slightly jaded because I tend to see the points where it goes a little bit wrong and we have to get involved in it. So filings and returns, I feel like I'm going to have a swear box by the end of the session, but, you know, strike off, it's happened. And I've been involved in, I would say, about a dozen where we've had strike-offs happen simply because people haven't filed their annual returns and their accounts. Companies House has chased them and then just taken action to strike them off the register. No one's done anything about it. And then we have had issues where, as I said, the freehold of the building has reverted to the Crown and we've had to take quite expensive action to sort that out. So you never want to get to that point. I think the thing is there, in some cases, housing associations will take on, as well as general kind of property management responsibilities, they will take on responsibilities for delivering company secretarial services, so you can make sure that's being done. And quite often you'll have a strong, well-resourced governance team who can take that on as well. Accidentally creating subsidiaries, I've already talked about triggering funder consent requirements and ultimately triggering an event of default under a funding agreement. We never want to get there. So thinking about, if you're having an issue with a management company where people just don't want to be involved, and that's one thing I'm talking about in a moment. If you're left holding the baby and you've ended up being the sole shareholder of that company, what do we need to do? You may need to notify your funders quite quickly and make it clear to them what you're doing to sort that situation out. I would hope, touch wood, unless you have a terrible relationship with your funder, they wouldn't take enforcement action on the back of that, given that it's a relatively low risk breach generally. But it is something just to be aware of, and we have had to agree waivers with funders on the back of that situation arising. Also, as I said, particularly where you have a significant interest in the development, taking steps to try and mitigate that risk at the outset. So thinking about, okay, we want to have a decent voting right so that we can make sure things are happening. We want to be able to put someone on the board so that we can make sure the day-to-day management is happening as we want it to happen. But we don't want to go down the road of creating a subsidiary accidentally. So what do we need to put in the articles to avoid that? So in terms of leaseholders and property owners not wanting to be involved, this is one that we see quite a lot. I certainly do, particularly where, you're 5 years down the line, the properties have changed hands a couple of times. People don't understand, that they're meant to be becoming a director. What can you do about that? So first of all is, if you are responsible for approving transfers, making sure it's being made clear to the person purchasing the interest that that is a requirement for them to be appointed as a director of a management company, or to take on a share, making sure that's happening as part of your completion processes, so that we don't allow the completion to happen until all the documents are sorted and in place. making it really clear, as I said to people, what they're expected to take on and what that means for them. Being cautious about giving them advice there, because obviously you're not there to be their legal or regulatory advisors, but kind of signposting them and steering them towards things that are useful in relation to what they're taking on there. The other thing, of course, is thinking about how you become aware of that situation. So if you have a significant shareholding in a management company, thinking about having a contractual obligation for the board of that company to let you know if they are getting to a situation where they don't have a number of shareholders. And that's something we have written into transfers and articles of association in the past. Abuses of power can be quite a difficult one, and I kind of alluded to this earlier. Quite often we have ones where you might end up, and I will say, as a health one, I'm not against resident management companies. I've seen them work really well. They tend to come across my desk where they don't work well, so that's why I sound slightly jaded on it. But for example, where you have a resident management company, you have a number of people who've been involved in it for quite a while and can sometimes see it as almost, their company, forget that they're there to serve the interests of all the residents and meet the obligations under the freehold or the leases, and they will decide, for example, well, I'm a director, so I don't need to collect my service charge, and also, I get on really well with my neighbour at number 10, so I'm not going to collect their service charge either, and I'm not going to take any action when they don't pay, and I'm going to, when repairs come up, I'm going to make sure I get mine done first because I'm a director. Or, for example, we've had ones where loans have been made to directors of management companies using service charge funds, which clearly they shouldn't be, because directors are there to act in the best interest of that organisation and not to seek inappropriate benefits in relation to that office that they've taken on. So we have been involved in various circumstances where we've had to remove directors from management companies, and there is a power within the Companies Act to do that. It's quite a convoluted process in terms of the steps that have to be followed, and quite a key thing there will be what level of voting authority you have as a shareholder or member. If, for example, you've got a block, you've got a number of leaseholders living there, the grounds maintenance isn't being done because ultimately the board are siphoning off money to themselves. Okay, what steps can you take there? A lot of that will depend on what level of a vote you have as a shareholder or a member, because you'll have to pass a resolution of the members, a simple majority. So it's, do we have that power ourselves? Can we get people to vote with us? How do we deal with that? So those tend to be the kind of fun disputes that we get involved in. Similarly, director disputes where directors fall out. Again, think what it's like with neighbours generally. You've got neighbours running a company together. That's always fun, isn't it? Think about the disputes with family companies. So some of the disputes which can arise there in terms of, well, so-and-so didn't tell me about this meeting, so I didn't get to come to it. This person's been doing something they shouldn't be. The loans issue, quite a common one. So again, dealing with that in terms of, we will quite often come in and be asked either to advise the board, either to give them a kind of smack on the wrist and say, you're not acting in accordance with the legal obligations, here's what's going to happen if you don't, or in some cases going back to that point of removing board members if necessary, to make sure the company can be run well. The other one we quite often get involved in, and again links back to what I said about accidentally creating subsidiaries, is a housing association realises it's got, I think my record so far is 55 management companies that it didn't realise it was involved in as a shareholder and member, and in 40 of those it had accidentally created subsidiaries. So that was a fun couple of weeks sorting that one out. And in that situation, how do we deal with winding that up, that company? How do we get the freehold transferred back in? What do we have to do about leasehold consultation? And really kind of simplifying that structure so that you can move to a position going forward where you're not running 55 companies that you don't want to be involved in and really don't need to be, given that other people don't want to be involved in them anymore. So I think that kind of brings me to the end of what I'm going to talk about today, and I'm ended on a humorous but slightly doom and gloom note. I think key messages for me really are thinking about what you're trying to achieve at the outset. Just because a developer you're working with presents you something as a fait accompli in terms of articles of association or the way their proposing arrangements are to be run, doesn't mean you have to go down that road. You do have certain negotiating and buying power depending on what you're taking on in relation to a development. I'm sure Stavrina will talk a bit more about some of the pushback we get from lawyers when we're working with developers, and the fact that they kind of go, well, that's the way we've always done it, but it doesn't always have to be that way. If you are thinking about appointing someone as director, making sure they're really clear on what their role and responsibilities are, think about that point around directors and officers liability insurance. It can be, in some cases, you'll be covered by the DLO insurance that your housing association has in place, but do check that, because we've had some people that have fallen into holes where actually they're not covered. And then what do we do in those circumstances? So yeah, really just thinking about where some of the things can go wrong. If you do get into a situation where, for example, you've accidentally created a subsidiary, or you have a management company and no one else wants to be involved in it, and you're kind of going, what do we do with it now? We're happy to advise on that further. I mean, I think it's something that quite often will be nuanced to the circumstances, but happy to have a chat after this session if anyone wants to get in touch for a kind of offline conversation. So I'll stop there for some questions. I think we've got a couple in the chat box. Let me have a little look. So the first one is, can a manco be set up retrospectively? So if we sold the properties but no longer want to be involved. Stav, is that something you've come across?
No, it isn't. So in most instances, we'll have the discussion beforehand. Yeah. So you'll make the decision beforehand whether or not you want to be involved or not. So I haven't come across a situation where we've created a management company retrospectively, because normally at the outset you already know what your plan is for that site, that building, that property, and so you get involved with dealing with the management company at the outset.
Yeah. So I've done a couple where, for example, there's the right to manage, obviously, and that's kind of retrospectively, because you've got people living in the development or the building, and they then exercise their right. So kind of going through that process with them. And I've done it on both sides, both where I've advised people on exercising the right to manage and setting up the company there, and also where I've advised housing association on how they deal with, a right to manage application. I've also done it where a housing association's interest has changed over time. So, for example, they've got rid of a lot of their units, or people have staircased out and things, and then they've kind of worked with a residents association in situ to then set up a management company that was run by them. So yes, it can be. I think you have to think about what's the relationship there. So, for example, if the freehold's going to stay with the housing association, how do you deal with subcontracting those roles and responsibilities from the housing association to the management company? And that can be by a management agreement, and then there could be a waterfall management agreement with another third party to do things on their behalf, or it could be that you look at transferring the freehold if that's something you're able to do. So, for example, if you don't have leaseholders living in that building anymore, you could look to transfer the freehold. So I've been involved in a couple where we've kind of walked through the process. I think the really important thing is, if you are looking at transferring the freehold, it will depend on the extent to which you've got residents in the building. If you don't, it's a much more straightforward process. Mark, did you want to say anything? So Mark's a partner in our housing management and litigation team.
Yeah, hi Gemma and Stav. Thanks. That was really interesting. Yeah, for those on the webinar, I'll be doing the second of these sessions, or be involved in the second of these sessions as a litigator. I can second what Gemma was saying about some of the scenarios that crop up again and again with management companies, and that's one of the questions I had for you guys. A lot of the pressure around the management company model at the moment is coming out of fire safety, and the fact that management companies can have the structure passed to them, and under the right to manage model, when the right to manage is exercised, the people take on the management function. So the company takes on the management functions, which can include the structure. And if you've got a management company which is not being properly run, or as Gemma says, has not been filing their documents, has been struck off, but they're the entity with responsibility. It can be very frustrating and potentially dangerous for leaseholders in those scenarios. At the setting up stage, are you now finding that there is a much more focus on who is going to be responsible for the structure of these buildings, which are going to be managed by a management company? And are people trying to pass the building safety buck, as it were?
Stav, do you want to comment on that one?
Oh, you're on mute, Stav.
I knew one of us was going to do it, Stav.
Yeah, it's only been 2.5 years.
Yeah, so we are finding out a lot more that they're sort of trying to pass the buck on. Landlords in general don't tend to want much responsibility at all. So yeah, we are finding a lot more pushback than previously.
Yeah, and I'm sure you'll cover it, Mark, as well, but certainly in terms of the management agreements, the extent to which responsibilities can be passed on or backed up by indemnities, we've seen a lot more negotiation around that, and something that management companies are trying to cover off a lot more.
Yeah, I mean, what we've seen is if you've got a well-drafted management agreement, or sometimes it's even baked into the leases themselves, is if you've got a step-in provision which allows the landlord to come in and step in and take on the responsibilities if the management company isn't doing what they're supposed to. And as I say, because some of the building safety costs can be so significant and the issue's so technical, that the people running the company either don't want to get involved or can't get involved, don't have the expertise to get involved, can't fund it. But if they are the entity which is legally responsible, it creates quite a difficult legal lacuna in those situations. So step-in provisions is certainly something which I have found useful when advising in those scenarios, because at least the landlord can step in. But where there is no ability for that to happen and the management company is just kind of a dead duck, it can become very problematic, because some of the stuff you were saying, Gemma, about how to wind up the companies and do that takes time. And so it'd just be interesting to see how much that's now being reverse engineered in the setup process. But it sounds like it's already filtering through, which I can't say I'm surprised by.
So we've had another question, which is about a management company that's walked off site. In this scenario, the housing association only owns a few units on the scheme, so 5 out of 30, but obviously there are those responsibilities to leaseholders, as mentioned. So struggling to get all customers to engage about appointing a new management company, that's common. In these circumstances, would you say push for right to manage or apply to the first year tribunal to appoint what's quickest or easiest? The freeholder's not interested in helping either. I'm shocked at that, Stephen. Mark, any thoughts on that?
Yeah, I mean, it's a tricky one. I mean, the problem with applying to the FTT to appoint a manager is there's only certain situations that can be done, and you have to have a manager who's lined up. Now, if you've only got 30 units, it's not usually that attractive for a management company to come in, especially if it's something which has got problems like that. So, I think I would rather be leaning towards the RTM in that situation as opposed to going to the FTT. But again, as ever, the devil's in the detail with these things. We'd have to look at the leases and see how the structure is specifically laid out in that scenario. But that it's a really good example of the issues that Gemma and I were just touching upon, about how these things can so quickly become problematic when the management company is not being properly run.
Yeah, absolutely. I mean, I think Mark's probably right. I suppose the other thing, is there anything you could do outside of those processes? So, for example, I mean, I don't know if you would want to take on responsibility as a housing association for managing it. Could you look at a managing agent arrangement there? It could potentially be something to look at. And if you want to have a conversation outside of this, Stephen, we can do that. That's fine. Another question in relation to right to manage. So glad you've got you here, Mark. If leaseholders have exercised their right to manage and established a right to manage company, will the right to manage company always be responsible for compliance with all statutory requirements relating to the management and fabric of the building, including fire safety?
Yeah, it's a good point, and it's something we're asked quite regularly. I mean, the thing is, what the right to manage does is a very strange beast, because it doesn't actually give the right to manage company any proprietary interest in the building. It transfers what are defined as the management functions from the landlord under the lease to the management company. So whatever the landlord is responsible for doing, by and large, under the lease, the management company the RTM company becomes responsible for. So if the landlord is responsible under the lease for those things, then yes, the right to manage company would become responsible. But also there's an issue between contractual requirements and statutory requirements, because the lease will lay out what the landlord is supposed to do, but by virtue of what they are doing and the areas they have an interest in, they can also take on statutory responsibilities under the regulatory reform order and the fire safety order, which will make them the responsible person. So in those circumstances, if they get transferred to the right to manage company, they become the responsible person. And in those circumstances, yes, the right to manage company would be responsible for the duties, fire risk assessments, things like that. But it all comes back to the contractual relationship. So it's what the landlord has and what is transferred by virtue of the right to manage being acquired.
Yeah. And again, if you'd like anything on that in terms of a more detailed conversation, just let us know. We can have a chat about that. It's probably a question for me now, which is good. So is there an obligation for a right to manage company or a resident management company to have an AGM? And should the members of the company be invited? So it will depend on what the articles say. So the Companies Act 2006 removed the requirement for private companies to have an annual general meeting of their members or shareholders. unless the articles say something different. So the standard RTM articles, off the top of my head, I think they make it optional, but I can check that. But if you're using, as we quite often see, a developer will have a set of articles from whenever, and they'll just reuse it over and over again. So quite often it will say you must have an AGM. So really it depends on whether the articles make it mandatory or not. If they do, or if the company decides to have an AGM anyway, even though it's not required to do so, all members or shareholders should be invited. And if they aren't, you can then use your rights as a shareholder or member to say that you've been unfairly prejudiced by not being invited to that meeting. We've had issues before where people haven't been invited to meetings as shareholders or members. So for example, we had one on a building safety dispute where the housing association was a party to the dispute, but then hadn't been invited to any of the shareholder meetings, and we ended up taking action against the management company. I say action, it was really some stern letters, but to make it clear to them that they're not allowed to do that. You can't exclude me in that way. I have rights as a shareholder and member. You need to make sure I'm being invited to that. So yeah, you should be. Yeah. I think that brings us to the end of our questions and the end of our webinar. So I would like to say thank you to Stavrina, who was fantastic, Mark for stepping on the questions of right to manage. I was very grateful. And thanks to everyone for attending. If you do have any other follow-on questions, do get in touch with us through our webinar's email address. Happy to come back to you on any further questions and to set up anything in terms of further conversation. I know we've had one person say they'd like a conversation about their particular query, so happy to set that up. As I mentioned, our second webinar on management agreements in particular with the wonderful Mark will be on the 13th of October, so please do sign up if you haven't already, and we'll look forward to seeing you there. Thanks everyone.
Thank you.
Thank you.